for this particular person and this particular employee, and even to a tribunal, it shows procedural unfairness. We have an employer who is trying to keep on the record, or put on the record, that I'm acting inappropriately, that I'm not doing things as I should be, and they're doing everything to help me and support me, and clearly they're not, because she didn't even want to inform HR of changes and things that I had requested, which was a mandatory requirement under the Equality Act of 2010. So sometimes, and quite often, employers and even tribunals will mischaracterize what you are doing, what you are saying, and your levels of cooperation, because that makes it very easy for the other person. So making sure you have a paper trail is very, very, very important, because paper trails escalate very, very concretely, or cemently I should say, with a factual base. And of course, the big no-no here is that this person had booked a meeting into my diary. I hadn't requested it. She'd booked it into my diary and was acting, as you can see there at the start, like all very matter of fact. And this is, in a sense, is very, very divisive, because what she was effectively doing was trying to put pressure on me, placing pressure on a disabled person to attend a meeting without representation is really, I would say, unlawful. Really bad, particularly in this situation where there were obviously legal things going on which they knew about, and they're trying to force me into a meeting without my legal representation. Now, lots of people would have buckled. They would have gone, oh my goodness me, that's my manager, I need to do what she says. So knowing your rights is really, really important, and you have rights. Now, I wasn't actually doing anything that was wrong, but even if there was a situation and you were in a meeting because you had done something wrong, you still have rights, and you still have the right to trade union representation. If you're not with a trade union, it can be a friend or somebody that you have trust. Now, I'm obviously showing this for educational purposes to help lots of you out, because so many of you are in the same situation, and it's very difficult when you are trying to navigate the organisations like the DWP, or even try and navigate tribunal processes, whether it's PIP, so whether your disability or your behaviour is being mischaracterised by the job centre or by a PIP assessor, and that is something that you just don't agree with, and you think, no, that isn't how I said it, that is not what I meant. And that is why keeping a record is really important, because all of these types of processes, they rely on the information that is recorded to make decisions and build characteristics, or kind of their opinion on you, if you want to look at it like that. Now, I'm going to go one step further. Now you have seen a very small, and I would say with what I had to deal with, that was very, very light. I mean, I consider myself to have been bullied and harassed for about 2 years when I was working there. That particular episode was very, very, very light compared to the other things I would have to be dealing with. But let's look at, given all of the information that I provided to the tribunal, and by the way, the tribunal have that recording and the transcript, let's have a little look at how the tribunal looked at me, even though they had that evidence and an awful lot more. And then I'm going to show you, if you're in this situation, how to deal with it without feeling like your whole world is imploding. And I think it's fair to say that this is definitely not legal advice. I am sharing my experience with you, how I dealt with it, and some pointers. Now, we clearly hear in that recording that I am asking this, she was my manager at the time, I was asking her to update HR, and she refused to. You heard her, she categorically refused to update HR. This is paragraph 95 of my judgment, and I will say please read, if you're going to read the judgment, please do read it, and quite frankly, with all respect to the tribunal, with a pinch of salt, because I have challenged a lot of that judgment. I believe there are lots of inconsistencies, and even here the judge has named somebody who is not even a witness. So I don't even know who this person is, because they're not a witness of mine, they weren't a witness of the respondent, so there's obviously an issue there. But it says, the claimant, who is me, now says is that it's inferring that now I'm saying something different, now says that Mrs. Durgety, that was a manager, and Miss Nye, that was a lady in the video, were very good friends. They'd worked together for many, many years, and suggests that they were colliding or conspiring against her. There were many incidences, okay, where things like this were happening. We find that whilst they had worked together previously, it was some years before. I'm just going to point out here, it doesn't matter. There, the time relevance is irrelevant. If you are feeling that if you feel that you're being bullied or harassed or discriminated against, how long people have known each other in this particular context is actually irrelevant. And it's rather odd that the tribunal is trying to make that relevance. Now, we're just going to put a question mark over that at this point. We accept that both women had a professional relationship and got on well at work. As might be expected, we find no evidence that the women were colliding or conspiring against the claimant, and are concerned at the claimant's allegation at this point that they... So my question has been to the court, then why on earth would a manager who is meant to be looking after my disability requests at work and dealing with them, which she had until this point failed to do, and actually throughout my whole employment there failed to do, why on earth would they then be reporting me to HR for a meeting saying that I hadn't attended it when it hadn't even happened? If that isn't conspiring against me, what is? But again, this is what the tribunal stated. Now, I'm just going to pull up another point. Now, that particular manager, there was a point in my employment there that I was in receipt of universal credit. That particular manager was going into my universal credit claim and looking at certain things, and she shouldn't have been doing that. The judge says that they don't find that there's a problem with that. Well, you know, the tribunal can state what they like, but I can tell you now, as a former civil servant, you are not allowed to go looking up people's information and going into their claims and doing all that sort of thing. So that's rather odd that the tribunal don't see a problem with that. But we are where we are with that. But what is really concerning here is that I stated, because of I had a grievance upheld against me, against that person, saying that I was being treated unfairly. We can clearly see how that person is attempting to gaslight me in a private meeting, because she thinks that nobody is listening and nobody else is going to tell. That I thought, no, actually, I don't want you dealing with my disability requests anymore, because quite frankly, at this point, nearly like 2 years in, I've got no confidence that you have my best interests at heart. How can you honestly expect a disabled person to have confidence in somebody doing something to help them with their disability when they're behind the scenes reporting you for things that haven't even happened, and doing all sorts of other odd things? And one of my disabilities is mental health, and I was off work for quite a while, about 6 weeks, with CPTSD, adjustment disorder, stress and anxiety. Those types of conditions can change very much your behaviour, particularly adjustment disorder. And the judge has, in my opinion, or the tribunal has, in my opinion, totally mischaracterized my behaviour that is 100% because of my disability as being rude. And this is actually a big flaw. So, and I know a lot of claimants struggle with this point as well. So I thought this would be really useful to bring this up. And then I'm going to bring up the laws that this kind of relates to. And again, This is not legal advice, but there's some pointers. And if this is happening to you, you might want to get legal advice and kind of like point them to these areas if they don't know, and hopefully they will know. But as we see here, it says, at this point, the claimant had, of course, raised a grievance against Miss Nye. And again, this had, of course, is like almost saying that I shouldn't have raised, you know, like almost saying, well, of course she was going to do this. Well, if you believe someone's mistreating you at work, you have the right to raise a grievance. So that is a little bit, if we look at that in the way it's written, it's a little bit of a telling sign. Now, the detail is always very important in all elements of a case, particularly in a judgment and how it's written up. And I'm going to go into this a little bit further because those two words, of course, actually indicate, I believe, something an awful lot more important than what you may be thinking of just looking at it like this. Now, this is where I am going to geek out a little bit because, like, I have a degree in applied linguistics, and this is the type of signalling with very small words that actually indicate very big thought processes or actions. Now, the issue here is not that the judge has noted that I raised a grievance. There's absolutely no issue with that. The issue is with the use of the words, of course. At this point, the claimant had, of course, raised a grievance because judges must make their findings and courts must make their findings based on evidence, and they should be avoiding assumptions about motives because everything needs to be proved in a court of law. And in particular, in this case, using the words of course is also potentially indicating apparent bias and a general consensus or an expectation that I would do this anyway, which is also showing a pre-formed judgment on my character. And why this is so important is because it changes the whole dynamic of perception. And that is incredibly valuable because it can flavour a judgment and it can flavour the outcome of a case. Let me give you an example. So looking at this paragraph 297, at this point, the claimant of course raised a grievance. Now, if the judge had written, at this point, the claimant raised a grievance against Miss Nye, that would have been factual, it would have been emotionless. However, because of course has been inserted, I believe this moves the judgment from this happened to this is the kind of person who would do this anyway.